All right, good evening, folks. Welcome to Monday Night Law here. What's this, April 15th? Might as well be April Fool's Tax Day. But anywho, glad to see you here, folks. I know I'm a little bit early tonight. Look at that. How's everybody doing out there? We're having pretty decent weather here in Idaho finally. Getting up there, we actually hit 80 degrees for the first time this year. The other day, wasn't quite that warm today. A little bit of rain earlier this morning, but still got stuff done outside I need to get done. So, whew. I haven't been paying attention a whole lot out there in the Trump administration or the fake Biden administration or any of that good stuff. So I did post something there on Telegram about Trump talking about that when he gets into office, if you when I have paid attention there, if we're all paying attention, watch what Trump is saying during his rallies and stuff. He was talking about how there's going to be a mass deportation, the biggest we've ever seen, of course. So, hi James, how you doing out there, brother? Out there on YouTube, good to see you, brother. Let me get my Rumble up and going here too, so I can watch the comments on that. Uh-oh. Apparently we're capturing the wrong screen here. Oh boy. Alright, so, nice little update on my software. I don't know why it's capturing the wrong screen. Aha. There we go. Okay. Okay, so for everybody else out there, except for Telegram, screen capture decided to change. Good old updates. Broadcasting software decided to change stuff, which is weird. So, those out there got to see the broadcasting software, me messing around with it, because it was capturing weird stuff. Anyways, yeah, kind of paying attention to Trump and some of the things he says there during his rallies. He's laying some stuff out there. Yeah, so here's kind of a going theme out there. Comment out here on YouTube. Klaus Schwab was said to have been arrested by Delta Force. Media claims he's sick and in the hospital. Thank you, Johnny, out there, YouTube. You know, this is the thing: is some of these people have already been arrested. Some of this stuff is just slowly coming out right now, but it's already happened. We're getting close to the wind down now. Possibly a wind up for America. being, Executive Order 13818, blocking the property of those involved in serious human rights abuse and corruption, which is the executive order from December 20th, 2017. Okay, this has been ongoing since 2017. And what it's really about is taking down bad governmental regimes and reinstituting new government, holding elections, and then doing a treaty of peace. And I'll keep saying this over and over again. How in the heck do you do a treaty of peace if you're not at war? So, just a little bit of logic, common sense, and reason here. You can't do a treaty of peace if you're not at war. So, hello, Executive Order 13818, which has been extended over and over and over again, because that state of emergency has not been, finalized, dealt with. And to a certain extent, I believe that America is basically just going to be the last, of course, saving the best for last. But, they're still dealing with some stuff over there in Israel and that kind of stuff. But Ukraine has pretty much been shut down. It's been taken over. And of course, not seeing a whole lot out there about Ukraine. Yeah, I wonder why. So those are just some key things to watch for on Trump's rallies and stuff, and some of the hints that he's laying down when he comes back in. I've heard him previously say something about when he comes back in, it might be sooner. So we never know when this is really going to happen. I know there's a lot of people out there that want it narrowed down to a certain date and that kind of stuff. And there's some people out there that are brave and put out certain dates on certain things, and it doesn't happen. Well, this is a military operation. We're under a continuity of government. It's a military operation. And I'm going to reiterate this again. If you're not in the need to know, we're not going to know. I'm not in the need to know. Back in the day in the Marine Corps there, it was always hurry up and wait, let's go. Well, what the heck are we doing? Well, I wasn't in the need to know. You'll do what you're told when the time comes to do it. And that's it. They don't, even in the military, they don't give us a full lowdown of what we're going to be doing. We don't get the bigger picture as little guys. We get this is what we're doing. And that's it. We have no idea about the bigger picture. So, Diesel D's, good to see you, brother. Oh, James. Here on YouTube. Klosh's hospital meals is a strict diet of grasshopper and crickets. Grasshoppers. Oh. Yeah. Right? Green energy. Well, I actually have a few things that I was going to go over tonight. One is going to be a piece of history, which I've gone over before, but a lot of new people following now. And I want to go over this particular document because it kind of pertains to what's actually been happening. And not so much here yet. But I want people to seriously think about this particular document from history when we get to it. There's a few other things I'm going to cover first that kind of actually pertains to my own case here and what I'm going to be doing here shortly, dealing with constitutional challenges. Okay? So I want to give thanks out there to Tony Franquito out of California, who sent me some more current of American jurisprudence constitutional law. Now, I've got 2019 stuff from the last time I was down there and gathered American jurisprudence. But this is, I believe, a 2021 version, which I've kind of compared the two, and they've shifted. So want to remind people that ever cite American jurisprudence, it changes every year. They're always doing this update. And in this instance, like the whole section has moved from where it was in 2019 to the next section. I don't know why. Maybe I added something in there. I'm not sure. I haven't gone through with a fine-tooth comb to figure it out. But I like this one section here, and then I went and looked at another section from the 2019, or this supposedly the same section. The verbiage was off, and I'm like, well, wait a minute. So I went to the next. Oh, there it is. So it's been changed a little bit. So again, I want to remind people who do research, and specifically using American jurisprudence, which is good stuff for the most part, depending on what subject you're talking about. But tonight's subject is going to be about constitutional law. So without further ado, I'm going to pop over here and we're going to pop some American jurisprudence up. Well, let me talk about this real quick first. This Texas Constitution. Now, where we're supposed to judge both the facts and the law in a real trial by jury where the people have all the power. In our common law courts where they can be criminal in nature, civil in nature, and where the people retain the right to judge the law, as we can read from still right in the Texas Constitution, and this is under that freedom of speech and press and libel. So go into that, and this is what it pulls up here. Section 8, freedom of speech and press and libel. Okay, I'm going to blow this up so people can really see it. And again, this is from the Texas Constitution, Article 1, Bill of Rights, Section 8. Every person shall be at liberty to speak, write, or publish his opinions on any subject, being responsible. See, a lot of people talk about accountable. The actual proper word is responsible. Okay? Accountable has to do with accounting. Responsible is being responsible for the actions. Okay? Responsible for the abuse of that privilege. Well, it's not a privilege, it's a right. We're talking about rights here. And no law shall ever be passed curtailing the liberty of speech or of the press. No law. None. That's also the First Amendment, or Article the First of the Bill of Rights. Congress shall make no law respecting the establishment of free exercise of religion, right? Or of speech and of the press. They're not supposed to make anything. They can't. They have no authority, no subject matter jurisdiction at all. Now, in prosecution of the publication of papers, investigating the conduct of officers or men in public capacity, or when the matter published is proper for public information, the truth thereof may be given in evidence. And in all indictments, wait a minute, an indictment for libel? That's right, because that's criminal in nature. We've got to have an indictment. Guaranteed. The jury shall have the right to determine the law and the facts under the direction of the court, as in other cases. This is February 15th, 1876. This right has never changed. Well, it has been subverted. The power has been stripped of the people to judge both the law and the facts. Just like it says, as in other cases. See, this was one of the checks and balances that we, the people, retained to ensure that the state legislature or even Congress, when they usurped their powers and made legislation regarding a certain right, or any legislation at all outside of delegated subject matter jurisdiction, period, or subverting personal jurisdiction, trying to apply legislation to the people when it has none of what the legislature make is supposed to apply to the people. It's supposed to apply to that which it creates through the statutes. The statutes is supposed to create. Well, man is a creation of God, so the people never delegated personal jurisdiction over the people to the legislature. No personal jurisdiction and no subject matter jurisdiction over any of our rights. Period. All right. So let's get into, this is volume 16, American Jurisprudence, second edition, Constitutional Law, subsection 108. And you see this is February 2021 update. So it's already 3 years old. Judicial power to determine the constitutionality of legislation generally. When we're talking about judicial power, yeah, that would be the people, right? That's right. The people retained that power. Although the doctrine of judicial supremacy was not established without dispute, it is now a settled principle of the American system of constitutional law that the courts have an inherent authority to determine whether statutes enacted by Congress or a state legislature transcend the limits imposed by the federal state constitutions, and to determine whether such laws are or are not constitutional. Now, if all political power is inherent in the people, and we have the right to alter, reform, or abolish anything at any time we deem it necessary, isn't that where we're supposed to be judging the law? In the courts? In our common law courts? Suits at common law, not suits in law. Article 3, Section 2. No, we're talking about suits at common law. Which can be, again, can be criminal in nature or civil in nature. They like to misconstrue Article the 7th and say, oh, well, that's for civil, that the right to trial by a jury is guaranteed in civil cases. No. It says, right, suits at common law. It doesn't say civil suits that are civil in nature. No, it says where the value exceeds $20, the right to trial by a jury shall remain inviolate. And no fact tried by a jury shall otherwise be re-examined in any courts of the United States except for pursuant to the rules of the common law. Those are them writs. But courts of the United States? They're all courts of the United States. Where's our common law courts? Where's the people's courts? Where's the justices of the peace that are elected directly by the people themselves? Remember, it's supposed to be of the people, by the people, for the people. A true republic. Not a monarchy. Back to a monarchy here. Back under Roman civil law, the code. I know, right, Mark? The left is still having a hard time with rights coming from God and nature and not from the government. We don't have constitutional rights. We've constitutionally protected rights, but our rights don't come from the Constitution. Hale versus Hinkle, our rights are long antecedent to the formation of the state. That's right, the laws of nature. We're endowed by our Creator with certain unalienable rights. Life, liberty, the pursuit of happiness. Back to them, Blackstone's commentaries on the law of England. Those three primary absolute rights from nature. The right of personal security, the right of personal liberty, and the right of private property. That's life, liberty, and property. Okay? So how do we not know this? Well, because nobody taught it. Nobody's done their own individual research and learned. But again, maxim of law, ignorance of the law is no excuse. And again, kids back in the day, by the time they were, 12 years old, 6th grade, they knew how to do some of this stuff. They already knew how to do their own paperwork. They already knew what their rights were. They already knew the law. They already knew how to do paperwork. Again, I'm going to remind people that, back in the day, 14 was the age of consent. Kids were getting married at 14 back in the day. So, notice that it says courts, above all else, have a duty to uphold the Constitution. That's right. And where a statute is in fact unconstitutional, the court's duty to declare it invalid, no matter how desirable or beneficial its purposes might be. Likewise, when an act of Congress is alleged to conflict with the federal Constitution, it is emphatically the province and the duty of the Judicial Department to say what the law is. That duty will sometimes involve the resolution of litigation challenging the constitutional authority of one of the three branches, but courts cannot avoid their responsibility merely because the issues have political implications. But I want to remind people about Article 4, Section 4. Luther versus Borden, that's a political argument, not a judicial one. The judicial branch just doesn't have jurisdiction there when we're talking about foreign invasion or domestic violence, which is, again, internal insurrection, an attempt to overthrow the Constitution and war against the people. There was a guarantee clause, guarantee a Republican form of government, to keep from turning us back into a monarchy. That's what that was really about. Re-implementing that Roman civil law, the code. And under the observation part here, the goal of constitutional adjudication is a simple one. It is to hold the true balance between what the Constitution puts beyond the reach of the democratic process and that which it does not. Now, this is where the confusion comes in. When they say democratic process, people think, well, that's democracy. No. That doesn't mean democracy. It's just the process. Where things are, through the process, it's done democratically. It's not a democracy. Doesn't mean that we're a democracy. So I think this is in part where the confusion comes from. So we're supposed to be a republic, and a republican form of government. Republican meaning in character and conduct of a republic, which literally means of the people, by the people, for the people. That's essentially what the republic means. It's done by the people. Where a monarchy is not a republic. It's done by the king and the prince. Some of it's done by parliament too, but those are some of the things that differentiate between a republic, a monarchy, and a democracy. Like in a democracy, anything can be put to a vote, and it's mob rule. People can vote to take your bike. That's a true democracy where everything is put to a vote. It doesn't matter. Now, in our republic, we require, technically speaking, it's supposed to be a 2/3. And that's where, I believe it was attributed to Benjamin Franklin, is what have we wrought, is a republic if you can keep it. But what's the difference between a democracy and a republic is it's like two wolves and a lamb voting on what to have for dinner. That's a democracy. See how majority rules? But in a republic, it only takes 1/3 to object to that vote. It's a well-armed lamb or sheep objecting to the vote. We have the right to object with arms. We're going to get into that. That's that other document I was talking about. All right, the constitutionality of a statute or ordinance is a question of law. There is a strong presumption that constitutional claims are judicially reviewable in some forum. That's forum, not form. It is within the special province and duty of the courts to say what the law is and determine whether a statute or ordinance is constitutional, and no express constitutional authority for such action is necessary. And see, here's what they're doing is they're saying that they have the authority to say what the law is. No, they most certainly do not. We, the people, laid down the law. Then we instituted government to secure those rights. We say what the law is. Even clear back in the day when Jeff Sessions was the Attorney General, he said, no. You don't get to say what the law is. The law says what it says as it is written. And that's something I used to say a long time ago, except for I always added, and not what you say it says it says. It says what it says as it is written. And if we're going to do any construing of rights or of the Constitution, it has to be construed in favor of the people and narrowly, it's supposed to be liberally construed in favor of the people who are the beneficiaries of government. And it's supposed to be narrowly construed when speaking about powers delegated to government. Very, very narrow. Very strict standard. So that saying that they have right here is that the courts are to say what the law is and to determine whether a statute or ordinance is constitutional. No, that's a false statement. See, the reality is here, they're supposed to be looking to the Constitution for subject matter jurisdiction, the power delegated. If that power isn't there, that power doesn't exist. Well, the argument is, well, does it say that we can't? That's not how that works. It's a delegation of power. You know how long it would take to actually write up a constitution if we had to seriously put in there every single prohibition on what powers they don't have? Come on now. Clearly, the assent of the executive branch to a bill which contains a provision contrary to the Constitution does not shield it from judicial review. True? But see, that's part of our checks and balance. See, the governor is supposed to go, no, you guys don't have that authority, and I'm vetoing this bill on the grounds that you don't have that authority. But see, this is also where we're supposed to be doing our remonstrances. In the middle of making that legislation, we would remonstrate against it and declare that, that's a protest, a formal written protest. That I'm objecting to you passing this legislation because you don't have the authority. Because. And again, a remonstrance does not have a prayer for relief. A remonstrance is really a formal written protest. That's how we're supposed to protest in writing. All this crap out here, standing on street corners and all that's not protesting. That's picketing. Signs. All right. A court applies its independent judgment in determining whether a statute violates the Constitution. Extrinsic facts are not needed to determine whether a statute is unconstitutional on its face. When assessing a challenge to the constitutionality of legislation, a court's duty is to determine whether the General Assembly has, there's a key word, General Assembly, Huh. Aren't we supposed to be reassembling our government de jure, part of that General Assembly? Has complied with the Constitution. If constitutional requirements are met, the wisdom of the legislature is a question for the General Assembly. Where state constitutions contain no specific provisions confining, limiting, or making subject to restrictions and qualifications the power of the courts to declare statutes unconstitutional, the judicial power is essentially unlimited, but a court having no general supervision or general veto power over legislation may not legitimately void a law merely because it does not like it or regards it as impracticable. Sure, I get that. But you got to look at who in the hell it applies to as well. But they've totally subverted all that regarding personal jurisdiction and subject matter jurisdiction. They even in the recent constitutionality challenge, nobody's challenging the actual verbiage of personal jurisdiction or subject matter jurisdiction. They just say, "Oh, well, that legislation that's unconstitutional because of this, that, and the other." They don't flat out say, "Well, the legislature lacks subject matter jurisdiction," or "This legislation was intended to apply to the people where they do not have personal jurisdiction over the people." A court's function when the constitutionality of a statute is put at issue is limited to a determination of the validity or invalidity of the legislative provision. Period. Either it is or it is not. Although a state court may apply a standard of review more stringent than the federal rationale basis test as a matter of state law under the state's equivalent to the Equal Protection or Due Process Clause of the 14th. What? Wait, are we saying we didn't have equal protection? Would that be Article 4, Section 1, Full Faith and Credit Clause, and due process from the 6th Amendment, or Article the 6th of Bill of Rights? I hate this 14th Amendment garbage because it's a shit made up amendment. When a state court reviews state legislation challenges violative of the 14th, it is not free to impose greater restriction as a matter of federal constitutional law than the United States Supreme Court has imposed. But see, they've taken that power from the people. The people have the power to abolish that legislation. We deem it necessary. What is this? States. Oh, that was permission. All right. States, by their constitution and statutes, can restrict the power of particular state courts to declare statutes invalid as violative of the federal constitution, so long as a reasonable opportunity exists somewhere in the state system to raise the federal constitutional issues. And then here's its cumulative supplement. A facial challenge to a statute is purely a question of law because the violation, if any, occurs at the point of enactment by virtue of the legislative assembly enacting a law prohibited by the Constitution. Well, it doesn't have to be prohibited by the Constitution. It just has to be no subject matter jurisdiction. See, they don't talk about subject matter jurisdiction. They don't talk about personal jurisdiction. A violation that occurs at the time of enactment does not depend on any facts or circumstances arising later. Just on its face, right? It doesn't have to be prohibited. The power has to be granted by the Constitution. And if that power is not granted by the Constitution, now back to the ones that I have regarding American jurisprudence. Let me see if I can pull that one up, because in my in mine from 2019 regarding American jurisprudence, Constitutional Law, Section 2. It does kind of hint at that. Oh, oh, here we go. I'm like, where did it go? Because it says that they look to the Constitution for the subject. So they kind of hint at it in Section 2 here, which again, this is Volume 16, Constitutional Law, Section 2. This was 2017, this particular one. Later ones that I got were in 2019. Constitution differs from a statute, and the statute ordinarily provides some details of the subject of which it treats, whereas the Constitution usually states broad general principles and builds the substantial foundation and general framework of the law and the government. The Constitution is a framework of government containing the general principles upon which the government must function, intended not merely to remedy existing conditions, but to govern future contingencies. It is a compilation of fundamental laws of the jurisdiction and embodies principles upon which the jurisdiction's government was founded. Constitution is made for the people and by the people. Well, no, it's not made for the people. It's made for the citizens, the public servants. Anyways, and is, above all, an embodiment of the will of the people, deriving its force directly from the people themselves. Statutes, by contrast, are enactments and rules for the government of civil conduct, promulgated by the legislative authority of a state. Instead of general principles, the statute provides details of the subject of the statute. Because Constitution constitutes a supreme law, they preempt contrary statutes or rules and stand above legislative law. They still want to call it law when it's not. It's policy. Statutes are policy. Period. It's not law. Thus, where a constitution speaks plainly on a particular matter, it must be given force and effect as a paramount law. And where a statute or other rule and a constitutional provision are in conflict, the constitutional provision must prevail. It has been said that a constitution is but a higher form of statutory law, so that, for example, the state constitution is looked to where a court is searching for statutory law on a subject. Subject matter jurisdiction must be delegated by the people in the Constitution itself. And there is no relevant statute per se. In any event, both constitutional and statutory principles should be liberally construed to further the goal of allowing the people to express their will. And see, there you go. They're trying to say, well, it should be liberally construed. No, it's supposed to be narrowly construed. And it must state with particularity. Otherwise, if the Constitution doesn't say it, then it doesn't exist. But as you reading between the lines there, what is it saying? One, back up here, that statutes, what? By contrast, are enactments and rules for the government of civil conduct. This is to control their conduct, not ours. And again, the courts are supposed to be looking to the Constitution for the subject matter jurisdiction in the Constitution itself for the legislature to even make legislation regarding that particular subject. Period. Hi, Scrimshaw. Good to see you. Jax, good to see you. Now I'm going to jump back over here to the other one. That was section 109. Or that was pardon me. That was all of 108? Holy smokes. This one is 109. Limitation on judicial power to determine constitutional legislation by statute or rule of practice. Judicial power to determine the constitutionality of state legislation may be subject to procedural limitations, as where statute requires that a state's attorney general be served. I just did that. Did I do that? Yes, I did. Idaho Attorney General has been served with notice of my appeal in the constitutionality challenges in that notice of appeal. Such a requirement is considered jurisdictional in some states, but not in others. In this regard, some states require service on the Attorney General only in declaratory judgment actions. In any event, the object of the requirement is to assure a fully adversary and complete adjudication of the constitutional issue, and to protect the state and citizens should the parties be indifferent to the outcome of the litigation. If a rule of practice so requires, a court may also refuse to consider a party's constitutional challenge to a statute where the party has failed to strictly comply with a rule of practice requiring that parties presenting constitutional challenges to statutes must file and serve separate written notices thereof with the state Supreme Court clerk at the time of filing such parties' briefs, even though the party did file the required notice at the time the party submitted the reply brief. So I've just sent the copy of the notice of appeal with constitutionality challenges. So when I do my brief, I will be doing the separate notice of constitutionality challenge, because that's a separate form. And that form will go to the Attorney General and the Appellate Court and the Supreme Court clerk, so that they're being made aware that there's a constitutionality challenge down here, and it's going to be me versus the Attorney General. So we'll see how this all works out. But it's time. It's time for this showdown, folks. The whole bar, the code, this Roman civil law, the code, Idaho Code, United States Code, Code of Federal Regulations, the UCC, Uniform Commercial Code. It's all code, folks. That's Roman civil law. It is foreign to our form of government, repugnant to our law, unacknowledged by our law. It's all unlawful. So if a rule of practice so requires, a court may also refuse to consider a party's constitutional challenge to a statute where the party has failed to strictly comply with the rule of practice requiring. Parties presenting constitutional challenges to statutes must file and serve separate written notices. Okay. The jurisdiction of certain courts to hear certain types of cases may also be limited by properly enacted statutes, so long as some... But that would be properly enacted statutes. There hasn't been any properly enacted statutes here in Idaho since 1881, when they implemented that enactment, that so-called statute of 1881, the Code of Civil Procedure. That's Roman civil law, the Code. So long as some type of remedy is provided, and so long as the remedy that is provided is adequate. Now, I can tell you right now, nowhere in the Idaho Code does it provide for any kind of constitutional challenges. I have looked and looked and looked. It's not there. It's like they don't want us to do constitutionality challenges. But again, that's all code. Roman civil law, ran by the bar. That's why they call it a license to practice laws, because they want the bar members, and only the bar members, practicing the Roman civil law, the code, because you have to have that title of nobility of esquire. But those days are coming to an end, folks. I'm telling you right now. Thus, when confronted with what appears to be a constitutional claim, a tribunal must first determine for itself that it has judicial authority to decide it. As an example, a state has discretion to channel appeals challenging the constitutionality of a tax statute to administrative process and a tax court, so long as those remedies are adequate, since the federal constitution does not require all state courts to hear federal constitutional challenges to the imposition of a state tax. But see, now they're saying, oh, well, that's administrative process. No. That's all back to the code. The Administrative Procedures Act in the United States Code. They don't have any authority to alter the fundamental law. Period. Our form of government and the whole system and how everything is working and has been working is so jacked up it's not even funny. But see, you have to know the real law and know how it's supposed to be in order to know what's unlawful to begin with. Like Administrative Procedures Act, the process. It was like 1854 or something like that when they did it. So it's like, why? Oh, well, in reading the legislation, it was the bar. The bar pushed this, well, for better administration of government. No, that's taking power away from the people. And again, there's already a case out there that talks about this on law.cornell.edu about due process of law of the land being due process of law, that it was manifest, it was not left to the legislative branch to enact any process as due process of law. Because again, due process of law comes from the common law. It doesn't come from legislative enactments. The legislature doesn't have the authority to alter the fundamental law or the Constitution. They don't have the authority to alter due process of law. But Roman civil law, the code, they can do whatever the hell they want to do because that's under a monarchy. Whatever the king says goes. Where Congress intends to preclude judicial review of constitutional claims, its intent to do so must be clear to avoid the serious constitutional question that would arise if a federal statute were construed to deny any judicial forum for a colorable constitutional claim. See, here again, how are they denying the right to challenge the constitutionality of any legislation? Also, rules of practice limiting judicial determination of constitutional issues which, although weighty, fall short of the status of principles ordained by the Constitution, may be made subject to exceptions where there are weighty countervailing policies. So now that we're using policies, so what are we getting into? Policies? I thought we were talking statutes, but now we're talking about policies. Then you talk about rules of practice. Talking about rules of procedure. Limiting judicial determination of constitutional issues will not be applied where the application would itself have an inhibitory effect on freedom of speech. I don't even know where, that's like totally out of left field. But it is what it is. It's all shit made up by the bar, guys. Absolutely, I totally agree with you, Scrimshaw. But what we're actually talking about here in this particular instance is, statutes, and doing constitutionality challenge of statutes. So any legislation that would come in conflict with a right should be void for any effect on its face, prima facie, and it should be met with an immediate constitutionality challenge. But the thing is again, we the people in our common law courts are supposed to be able to judge both the facts and the law. What the legislature made, again, all political power is inherent in the people. We have the right to alter, reform, or abolish anything at any time we deem it necessary. And one of the instances where previously in history where it was actually exercised was in the trial by jury, where the jury says, no, we the people did not delegate the state legislature that subject matter jurisdiction in the Constitution. And we declare that and abolish it. But see, we've all been dumbed down. We don't know that. So we don't quite comprehend and understand what's even the words that are on the screen right now is all unlawful. This is all bar word salad. These are all cases. This is the judicial branch taking power, right? Because remember, where in the Constitution did we delegate the judicial branch power to make law? And that's exactly what they're doing. Well, we're going to say what the law is. No, we the people say what the law is. You're supposed to be the servants, and you're supposed to be bound to support the Constitution, the supreme law of the land, and the Bill of Rights. But interestingly enough, I was doing some research on the Federalist Papers. I think it was Federalist number 84, talking about titles of nobility and that kind of stuff. And Alexander Hamilton was talking about bills of rights. That we don't even need bills of rights because those rights, they're already there. It's already the law. Bills of rights were for kings to prohibit kings. But in our republic, we don't need them because the people are the sovereign. Uh-oh. So forget the frickin' Bill of Rights. Do you know what your rights are? Bills of rights are for kings. But like it says in American Jurisprudence, Volume 16, Constitutional Law, Section 100. Oh, I had that one pulled up. This is getting into that mandatory language, you know. A constitution is usually a declaration of principles of the fundamental law, many of its provisions being only commands to the legislature to enact laws to carry out the purpose of the framers of the... What? Would that mean that subject would have to be in there and we would be telling the legislature to enact laws regarding that particular subject? We picking that up right here? Or mere restrictions upon the power of the legislature to pass laws. However, it is entirely within the power of those who establish and adopt the Constitution to make any of its provisions self-executing that is operative without any necessity for further legislation. Okay. Yeah. Too much time at the bar. You visit the bar? Back in the day, I sure did. The drinking kind of bar. Criteria which may be relevant in determining whether constitutional provision is self-executing or not include a description of the right in detail, such as the means for its enjoyment and protection, the absence of any directive to the legislature for further action, a particular informative legislative history as to the provision's intended operation, and a consistency of self-execution with the scheme of rights established in the Constitution as a whole. Now, this is where it gets interesting. Even without the benefit of a declaration that they are self-executing, constitutional provisions in bills of rights, that's plural, and those merely declaratory of the common law, are usually considered self-executing, as are provisions which specifically prohibit particular conduct. What? Our rights are merely the bills of rights, and our rights are just merely declaratory of the common law? It's already the law. And like Alexander Hamilton, quoting him in his Federalist 84 there, the bills of rights are particularly for kings and for monarchies. We don't need him in a republic, because that was part of his argument of why against the Bill of Rights to begin with is, well, we just don't even need a Bill of Rights because bills of rights are for kings. But in my mind, what that was an attempt by Alexander Hamilton to not even have a Bill of Rights. But I think the next Bill of Rights that's made, there should be hundreds of enumerated rights in there to really give it the full effect a Bill of Rights needs to have. And I'm well aware of Alexander Hamilton being a traitor, by the way. A clear distinction exists between the questions whether constitutional provision is mandatory or directory and whether it is self-executing or requires legislation in order to give it effect. A provision may be mandatory without being self-executing, and a provision may be self-executing even though it contains some mandatory language. It doesn't matter. It's already self-executing when we're talking about bills of rights because it's already the common law. Okay, and back to this one over here because like this one here, the people's constitutional standards must always prevail over the legislature's statutory standards, should the latter be lower. Right, because the people are the higher authority. Statute exempting taxi cab drivers from minimum wage requirements was repealed when the minimum wage amendment to state constitution took effect, not when Supreme Court decided that the amendment impliedly repealed the statute. Supreme Court's function was to declare what the law was, not to create the law. But see, again, to declare what the law was, not to determine what the law is. Statutes are construed to accord with constitutions, not vice versa. Oh, yeah, that's right. Now back to the other one, we're section 109. See how some of this kind of, it like contradicts itself. Yeah, notice the Attorney General, the Constitution of any state shall appeal is required on appeal as well as the trial court level. Uh-oh. Should be section 110. Kind of want to skip over this one because executive branches are not empowered to determine whether the law is constitutional. The duty belongs to the judiciary. From the very nature of the American system of government, with constitutions prescribing the jurisdiction and powers of each of the three branches of government. Well, how is that? Wait a minute. From the very nature of the American system of government, with constitutions prescribing the jurisdiction and powers of each of the three branches of government, it was devolved on the judiciary to determine whether the acts of the other two departments are in harmony with the fundamental law. All the departments of government are unquestionably entitled and compelled to judge of the Constitution for themselves, but in doing so, they act under the obligations imposed in the instrument and in the order of time pointed out by it. Again, when the Constitution dictates the process, that's the way it's supposed to happen. Not any other way. That's a subversion of the law. The judiciary has once spoken, if the acts of the other two departments are held to be unauthorized or in violation of the Constitution or vested rights of the citizen, they cease to be operative or binding. Thus, the final responsibility passing upon the Constitution of the state rests upon the courts. The right to declare and act unconstitutional is purely a judicial power and cannot be exercised by the officers of the executive department under the guise of the observation of oath of office to support the Constitution. Well, no, that's not true either, because in our form of government, again, the executive branch does provide oversight. The oath of office to obey the Constitution means to obey the Constitution, not as the officer decides, but as judicially determined. No, even the judicial branch has to follow the Constitution. For every law found on the statute books is presumptively constitutional until declared otherwise by the court. No, that's not true. gubernatorial veto. The executive is supposed to provide initial oversight right from the get-go. So, another lie, because see, the bar has full control of the judicial branch, and they want to be able to determine whether, no, it's fine. No, it's okay. No. Again, this power needs to be returned to the people. And it's not a matter of returning it, it's a matter of the people taking it back. We have the right to take back our powers that have been stripped from us. And that has to be done by reassembling government de jure. There is no other way around this, folks. That particular point. We want our powers back. We want government to get back in line. We want to start holding public servants responsible. Then we need to reassemble. Because without being reassembled, we don't have that power. All of this stuff is all just happening under martial law, waiting for the people to reassemble, to take back their powers. All right. I think it was 111, or was it 112? Where the issue is whether particular legislation conforms with or contravenes a state constitution, ordinarily all courts within the state have the power and duty to determine the matter. But the court of last resort of the state is the final arbiter. The state Supreme Court is the final arbiter of the state constitution and may interpret the state constitutional provisions more broadly than corresponding provisions of the federal constitution. They're not the final say, because you can appeal from the state Supreme Court to the Supreme Court of the United States of America. Only a court of competent jurisdiction has the power of judicial review and the solemn responsibility to strike down a statute that runs afoul of either the federal or state constitutions. Federal courts, as a general rule, are inclined to refrain from passing upon the conformity of legislation with the state constitution, since they are usually concerned only with whether state legislation offends the federal constitution. Acts of state governors, however, are reviewable in the lower federal courts as well as the United States Supreme Court. It's not called the United States Supreme Court, it's Supreme Court of the United States of America. See, again, bar word salad. In the United States, federal constitutional issues can be litigated not only in the federal courts, but also in state courts. That's kind of backwards, ain't it? But hey. Section 112, judicial powers to determine constitutional limits imposes obligatory duty. Okay, this is where it's kind of going to get serious. Since the Constitution must be obeyed by the judiciary as well as the other departments of government, and the judges are sworn to support its provisions, courts are not at liberty to overlook or disregard its commands, or countenance evasions thereof. It is their duty in authorized proceedings to give effect to the existing Constitution and to obey all constitutional provisions irrespective of their opinion as to the wisdom or desirability of such provisions, and irrespective of the consequences. Thus, it is said that the courts should be and are alert to enforce the provisions of the Constitution and guard against their infringement by legislative fiat or otherwise. Gee, the judge in my case didn't do that. And I brought him up, and I challenged it. Why? Why didn't he uphold the provisions of the Constitution? Why didn't he uphold the provisions of the Bills of Rights? His butt's going to be in hot water here real soon. Just saying. If a statute violates a mandatory provision of the Constitution, the court is required to declare such an act unconstitutional and void. You are required. The duty of the court in a proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the deliberate judgment of the tribunal before which the validity of the enactment is directly drawn into question. Once it is determined that a statute encroaches on constitutional limitations, the Judicial Department must not hesitate in condemning it. Thus, there rests upon the courts the affirmative duty of refusing to sustain that which by the Constitution has been declared repugnant to public policy. See? Statutes are policy. Public policy. See, they're in the public. We, the people, are in the private. We are at law. Private. Article 3, Section 2 is in law. That's in the public. Not to be confused with out here in the general public. But see, that's a confusing, I know that's a very confusing thing to say, is private and public. Most people are led to believe that as soon as you walk out your door and you go out here on the streets and highways, you leave your private property, you're now in the public. That is false. We're always in the private unless we engage in the public, which requires a contract and an oath of office in most cases, pursuant to Article 6, Clause 3. Every member of the legislative, executive, and judicial branch, both state and federal, shall be bound by oath or affirmation to support this Constitution. They are the citizens. Whether they're elected or appointed into a position of public trust or not is irrelevant. You're a part of the legislative, executive, judicial branch. You're receiving taxpayer dollars. You shall be bound by oath or affirmation to support this Constitution. In Article 6, Clause 2, the judges in every state shall be bound thereby. Anything in the Constitution or laws of a state to the contrary are notwithstanding. Marbury versus Madison, 5 U.S.C. 135, right? U.S. 135. Okay? Again, anything that comes in conflict with the supreme law of the land is void for any effect from its inception, void ab initio. And supporting, protecting, and defending the Constitution by giving effect to the provisions of the Constitution, even if in doing so doing a statute is held to be inoperative. This duty of the courts to maintain the Constitution as the fundamental law of the state cannot be evaded. So, this is where I go into trying to teach people about how to bring this stuff up in court. You got to bring this stuff up. And then 113 is kind of just a more reiterating the same thing. The exercise of the right and power of judicial tribunals to declare whether enactments of the legislature exceed constitutional limitations and are invalid is one of the highest functions and authorities of the courts. Now, notice that it just references of the courts, right? Of the judicial branch of the courts. Nowhere does it say judge. See, again, this is supposed to be done by the people, of the people, by the people, for the people. And I'm reiterating again, all of it, not some of it, not most of it, but all political powers inherent in the people. And the people have the right to alter, reform, or abolish anything at any time we deem it necessary. So what do you think that means? Why do you think they wanted to strip us of the right to judge both the facts and the law in a trial by jury? Because the people would have the power to abolish this unlawful legislation. Well, they can't have that. Then we're not a republic. We're a monarchy. We have a set of men, these esquires, holding that title of nobility of esquire, which comes from the British crown. It's from a king. I've talked to a couple of different members of the bar on this. Well, esquire is not a title of nobility. Are you trying to play me for a fool? You think I'm stupid? That I don't know what the hell I'm talking about? Really? Give me a break. It involves a grave responsibility and a solemn duty, and is at all times a matter of much delicacy. By way of contrast, however, courts also have a solemn duty to avoid passing upon the constitutionality of any law unless compelled to do so by an issue being squarely presented to and confronting the court in a particular case. Thus, courts should endeavor to implement the legislative intent of statutes and should avoid constitutional issues wherever possible. What about that? What about that legislative intent? What about that being enacted by the legislature of the state of Idaho or state of whatever? It's in every state constitution. You have to have that enacting clause. Now, when you go to your Idaho code or codified law, revised code, it's whatever it's called in your particular state, it's all Roman civil law. It's all code. Some states really try to hide it, but when you pull that sucker up, where is it at? Where's the enabling act? The enabling clause? It's not there. Because it's all code. Roman civil law. And it's all enforced by bills of pains and penalties. Bouvet's Law Dictionary 1856 under law, civil. And the Roman civil law code is opposed to the law of nations, the laws of nature, and the common law. See? Blackstone's Commentaries on the Law of England lays out the three fundamental laws: Roman civil law, the feudal law, and common law. Those are three separate jurisdictions as a fundamental law. Law of Nations, Book 1, Chapter 3, Section 34. The question was asked and answered. Does the legislative branch have the authority to alter the fundamental law or the Constitution? The answer is no. Because the people laid down the law. The people created the instrument of government known as the Constitution to secure these rights. Imagine that. No authority to do that. And they did. Created the American Bar Association in 1878. Seems right around that Reconstruction time. Yeah. Fundamentally altering our Republican form of government, huh? Yep. Wonder why that Executive Order 13818 came out. Blocking the property of those involved in serious human rights abuse and corruption. Once the legislative branch has exercised its authority to enact a statute, whether through legislative referendum or a bill signed by the governor, it is within the court's inherent power to interpret the constitutionality of that statute when called upon to do so. Yeah. Courts exercise the power to declare legislation unconstitutional with great restraint. Why? The courts invariably give the most careful consideration to questions involving the interpretation and application of the... interpretation. No, you don't get to interpret the supreme law of the land. You do not get to interpret the law of the land. It's made by the people, and you're bound to support it. You do not, judicial branch, none of the branches of government has the authority to interpret the Constitution. It's commands from the people. Your boss. You're the servants, we are the masters. Servants never get to interpret the commands from the master. It's time for the people to take back their rightful powers, folks. We have to come together. We have to do this, folks. You know, there's going to come a time here where the military is going to come in and declare this martial law and take down the bad governmental regimes. Executive Order 13818. And we'll be stuck under martial law, which we're already under martial law right now. And how do you like it now? I mean, it's going to be better, I think. But in order for us to fully function as a Republican form of government, we have to reassemble the common law side of our Republican form of government where the people have the power. All political power is inherent in the people. Not American state nationals. It's all political powers inherent in the people. You need to be one of the people, not a national. National is shit made up in the United States Code by the United States Inc., by the bar, also in 1878. Otherwise, national as a noun, as a status, didn't exist at all. Nowhere. And I'm being very specific. As a noun, as a status. As in national, meaning the whole nation as a whole, sure. But not as like American state national, which even that whole phrase doesn't even exist anywhere. The word national as a noun in the United States Code does. But again, that didn't come into existence until after the Reconstruction Acts. And it's in the code. You won't find it anywhere in history of bills of rights or any constitutions or anything like that. You won't find it in the law of nations. It's not there. Doesn't exist. That word as a noun doesn't exist in the law of nations. Judy out here on YouTube said, they don't obey the laws of nature and have no ability to understand them. They are spiritually blind. Well, it's not them, it's you. We're supposed to know. Ignorance of the law is no excuse. Right? Knowledge is power. If you don't have this knowledge, you have no power. And then once you are empowered, you must learn how to wield that power like a double-edged sword. Okay? We are the ones that are supposed to claim it and exercise it and defend it. Don't expect anybody else to do it for you, including some police officer or some wannabe judge who's just a black robe wearing frickin' Roman Catholic Church, wearing a black dress. That's the signification of the Pope. No, I disagree, James. I hear personal is a word that equals slave. No. That's not true. like personal security, personal liberty. Now, I agree with the word person has been misconstrued and is supposed to signify essentially a corporation, but English Bill of Rights of 1689 talks about the Prince and Princess of Orange, right? The name and style in their being present in their proper person. So, like mother and father would be considered a person, right? Because you have man, and man creates mankind. We procreate pursuant to the laws of nature. Attraction of the sexes, one of those 6 primitive laws of nature, the attraction of the sexes. But mother and father essentially is a person, because if you don't have a son or a daughter, then you're not a father or a mother. You're just man. So there's a fine line there. We just have to know what those persons are. And even the Fourth Amendment specifically states the right of the people. See, there again, the right of the people, not the right of the nationals, the right of the people to be secure in their persons. Papers, houses, and effects from unreasonable searches and seizures shall not be violated. So there are certain persons that have nothing to do with government. Then there are those persons that are created. It's like a personality, a personificance. So it's in propria persona. It's a persona, personificance. All right, so pretty much covered what needs to be covered here. That everybody get it. Everybody get that the courts cannot evade this power. But again, back to when we get back to the people having this power, we got to get reassembled. And then we get to alter, reform, or abolish this legislation, any legislation that the legislature makes, because again, that's one of the ways that we exercise that political power and maintaining our republic and keeping the legislature in check. Yeah, it's supposed to be done in the courts, but it's supposed to be done by the people, of the people, by the people, for the people. That's our true republic. Now, for the bombshell, okay? Here we go. I know some of may know this, but this is, in short, it's the Declaration for the Causes and Necessities for Taking Up Arms. This is July 6, 1775. And I think this is an appropriate thing to cover again, given some of the recent stuff on the right to keep and bear arms. And notice it's the words here, folks. The right to take up arms, not firearms, just arms. Listen carefully, folks. If it was possible for men, not persons, who exercise their reason to believe that the divine author of our existence intended a part of the human race to hold an absolute property in and an unbounded power over others, marked out by his infinite goodness and wisdom as the objects of a legal domination never rightfully resistible, however severe and oppressive, the inhabitants of these colonies might at least require from the Parliament of Great Britain some evidence that this dreadful authority over them has been granted to that body. Gee, would that be personal jurisdiction over the inhabitants? Yes, it most certainly would be. And again, look at these words. The inhabitants, not nationals. Men, not persons. But a reverence for our Creator, principles of humanity, and the dictates of common sense must convince all those who reflect upon the subject that government was instituted to promote the welfare of mankind and ought to be administered for the attainment of that end. The legislature of Great Britain, however, stimulated by an inordinate passion for a power not only unjustifiable, but which they know to be peculiarly reprobated by the very constitution of that kingdom, and desperate of success in any mode of contest, where regard should be had to the truth, law, or right, have at length, deserting those, attempted to effect their cruel and impolitic purpose of enslaving these colonies by violence, and have thereby rendered it necessary for us to close with their last appeal from reason to arms. In short, being oppressive, assuming powers they don't have. To hold an absolute property in and unbounded power over others, personal jurisdiction, marked out by his infinite goodness and wisdom. And what is it? I want to reiterate this. The inhabitants of these colonies might at least require from the Parliament of Great Britain some evidence that this dreadful authority over them has been granted to that body. Delegation of power. There was no power delegated personal jurisdiction over man, the people, in the private. And I'll challenge any man or woman out there to show me where the people granted personal jurisdiction over them. In the private. Hale versus Hinkle. Right? That the citizen may carry on his private business how he sees fit. His right to contract is unlimited. He owes no duty to the state to open up his books to his neighbor So not even your neighbor. We have no duty to open up our books and papers to even our neighbor or the state. We owe no duty to them. It's in my paperwork in the court case. Like I said, it's going to be a good one, folks. Thereby rendering this. Yet, however blinded that assembly may be by their intemperate rage for unlimited domination, so to cite justice and the opinion of mankind, we esteem ourselves bound by obligations of respect to the rest of the world to make known the justice of our cause. Would that be like that probable cause? Yeah, probably. Now this is, again, a great piece of history right here, folks. It's very illustrative and illuminating. What is it? Our forefathers, inhabitants of the island of Great Britain, left their native land to seek on these shores a residence for civil and religious freedom. What was the intent of leaving Great Britain? Because they were violating our rights and our right of religion. Trying to force us under the monarchy, under Catholicism as an ideology from the Roman Catholic Church. Where the good Christians, the Protestants, the Saxons, wanted to exercise their religion, and the way they want to exercise religion according to the dictates of their conscience. Not by the king. Not by the Pope and the church and the priests and all that good stuff. No. So, if anybody ever asks, why did we leave Great Britain? Right here. Statement of fact. Going clear back to the Magna Carta 1215, they were trying to separate religious separation, clear back in 1215 from the Roman Catholic Church. That's a fact. At the expense of their blood, at the hazard of their fortunes, without the least charge to the country from which they removed, by unceasing labor and an unconquerable spirit. Come on, people. Let's get that unconquerable spirit back. They effected settlements in the distant and unhospitable wilds of America. See, America. Then filled with numerous and warlike barbarians. Oh, but I thought we came over here and we killed all the Indians. They were already warring against each other before we even got here. That's in a state of nature of mankind as a whole worldwide. Been that way for a long time. Always fighting one another. So here's again another piece of history that's a fact, calling them warlike barbarians. Societies or governments vested with perfect legislatures were formed under the charters from the crown, and harmonious intercourse was established between the colonies and the kingdom from which they derived their origin. The mutual benefits of this union became in short time so extraordinary as to excite astonishment. It is universally confessed that the amazing increase of the wealth, strength, and navigation of the realm arose from this source. Hmm. Imagine that. And the minister who so wisely and successfully directed the measures of Great Britain in the late war publicly declared that these colonies enabled her to triumph over her enemies. All the way from over here. Towards the conclusion of that war, it pleased our sovereign to make a change in his counsels. From that fatal moment, the affairs of the British Empire began to fall into confusion, and gradually sliding from the summit of glorious prosperity to which they had been advanced by the virtues and abilities of one man, are at length distracted by the convulsions that now shake it to its deepest foundations. The new ministry, finding the brave foes of Britain, though frequently defeated, yet still contending, took up the unfortunate idea of granting them a hasty peace and then subduing her faithful friends. All right, folks, no hasty peace. Nope. Not this time around, folks. These devoted colonies were judged to be in such a state as to present victories without bloodshed, and all the easy emoluments of statutable plunder. The uninterrupted tenure of their peaceable and respectful behavior from the beginning of colonization. That'd be clear back in, 1606 and just a little like Jamestown, Virginia, with the first charter of Virginia of 1606. Their dutiful, zealous, and useful services during the war, though so recently and amply acknowledged in the most honorable manner by His Majesty, by the late King, and by Parliament, could not save them from the meditated innovations. Now pay close attention to this part. Parliament was influenced to adopt the pernicious project and assuming a new power over them, having in the course of 11 years given such decisive specimens of the spirit and consequences attending this power as to leave no doubt concerning the effects of acquiescence under it. Roman civil law code, again in history. That's assuming that new power over them. Well, under the Roman civil law, they're the ones that have the power to make whatever legislation they want. They don't care about any constitution. They don't care about the Magna Carta. They don't care about any Bill of Rights. They don't care about the English Bill of Rights of 1689. Another point in history. The same damn thing over and over and over and over again throughout history, folks. This is not the first time we have been here. But this time, there's a little bit more to it. Now we're getting into exposing the satanic rituals and the pedophiles and the pedophilia rings and, all that fancy stuff. Which is why they have to have control so that they don't get found out. Period. This is what's going on, folks. They're all being exposed. Trust me. Believe me. It's already out there. But they've been eating babies. They've been killing babies. There's been lots of stuff going on for thousands of years, folks. Thousands of years that this has been happening. This is going to be one heck of a enlightenment, an awakening. You're not aware of how things have been running for like a couple thousand years, 4,000 years plus, with the satanic rituals, adrenochrome, organ harvesting, everything they can do to enrich their own lives, extend their lives, drinking the blood, and all that. There's all sorts of just crazy stuff that's been going on underground, in the tunnels, under the White House. Okay? This is the stuff that's coming out now. It's slowly being leaked out. Now, I know that there's some people out there that are aware of this stuff and awake to this stuff. But I would say there's still probably close to 65% of the population, at least, maybe if not more, that have no clue about this kind of stuff. They have undertaken to give and grant our money without our consent, though we have ever exercised an exclusive right to dispose of our own property. Huh. Doing the same thing over and over again, aren't they? Statutes have been passed for extending the jurisdiction of courts of admiralty and vice admiralty beyond their ancient limits. And that's admiralty jurisdiction. Those are suits in law. Article 3, Section 2 under admiralty and maritime jurisdiction, right? Admiralty jurisdiction, maritime law. Law of the water. Military. Taking away our common law courts and creating these admiralty courts. But see, there again, this is all going back to Roman civil law, code. Oh, what's this? For depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property. Huh. It's trial by jury, not jury trial. How about traffic infractions? Do you get a trial by jury for a traffic infraction, even though property, money? Those are all bills of attainder, bills of pains and penalties. Traffic infractions, it's a fine. For suspending the legislature of one of the colonies, for interdicting all commerce to the capital of another. That's in part that admiralty jurisdiction and commerce. See how those kind of go hand in hand here? Article 1, Section 8, Clause 3 delegates the subject matter of commerce, and it's foreign commerce between the states, foreign commerce in between the Indian tribes. There's no real interstate commerce there. Go read Federalist 45. And for altering fundamentally the form of government established by charter and secured by acts of its own legislature solemnly confirmed by the crown. They just straight up just hijacked all the government and killed people, and it, basically the Reconstruction Acts, the Civil War. 1861 to 1863 with the Lieber Code. So, here it is, marked in history. Reasons for taking up arms. And it's exactly where we are at again today. This is July 6, 1775. In the Continental Congress. Continental. For exempting the murderers of colonists from legal trial and in effect from punishment. Oh, well, we did our own internal investigation and we found no fault of the police officer. Huh. Does that sound familiar? For erecting in a neighboring province acquired by the joint arms of Great Britain and America a despotism dangerous to our very existence. And here we are. This goes in line with what Trump was talking about and the Third Amendment. And for quartering soldiers upon the colonists in time of profound peace. Now, I'm going to apply that to here today. You see, a well-regulated militia being necessary for the security of a free state. Where does it say a well-regulated policy officer? Because it's actually pronounced policy, not police. Aren't we paying these people? These men and women as policy officers? So instead of quartering them in our own homes, we're paying them to quarter them in their own homes. Is that not repugnant to the Second Amendment? Is that not repugnant to our form of government? I mean, it's in the Declaration of Independence. Erecting a multitude of new offices, sending hither swarms of officers to harass our people and eat out our substance. That's what they were talking about, these policy officers. They were here enforcing those, what? Bills of attainder, bills of pains and penalties. And they will try to say that, well, bills of attainder are felonies that didn't allow for a trial. And bills of pains and penalties were misdemeanors that didn't allow for a trial. That's a half-truth. Because Bouvet's Law Dictionary, 1856, defines a bill of attainder as legislation, comma, punishment, period. And Bouvet's Law Dictionary under law, comma, civil, says that the Roman civil law, the code, is all enforced by bills of pains and penalties. In the English Bill of Rights of 1689, for promising an award prior to any conviction or judgment. So when they say, oh, that is a certain amount of a fine, if you do this, there's a fine and jail time, fine or jail time. That's legislation that prescribes punishment. Because see, suits at common law, whether it's criminal in nature or civil in nature, what are the actual damages? That would dictate not really a fine, but that would be the fine. But who's supposed to get the fines? The injured party. At no time can they, the government side of things, enrich themselves off of the fines. That's an unjust enrichment. That's a foreign emolument. They're already supposed to be on the clock getting paid. Why then are they getting parts of the fines? They got court costs, and they get parts of the fines. In fact, they get the whole fine. They just divvy it up amongst themselves, put it in their coffers. You got the judge's retirement fund. A certain part of the fine goes to the judge's retirement fund. A certain part of the fine goes to the arresting police department. So they're getting a kickback. How is there not an equitable interest? Yes. I'm gonna. The Ken over here on Telegram is citing from Joseph's story, and this is a good one. Simply put, says Joseph's story, the salient purposes of the militia of the several states is to be the ever-present, ever-feared, and thus ever-effective check and limit to any government office holder, agent, clerk, or employee who would use his position, power, or office to trespass upon any person's God-given rights. See, it's a trespass because our rights are our property, because property is an aggregate of guaranteed rights. Those are those unalienable. You can't place a lien on them because they are our property, private property, not real property. It's just property. That's why it's called a common law trespass. And that is what the militia is supposed to be for. The organized militia, state level, is to protect us from foreign invasion from a state. The national organized militia is supposed to be out there on the water, defending America as a nation from all things foreign to the nation. They're the ones that are supposed to be manning the ports of entry, military, because that's organized militia is military. But the militia is composed of the body of the people themselves. And from that body of the people is where the well-regulated, the organized militia comes from. It has also been resolved in Parliament that colonists charged with committing certain offenses shall be transported to England to be tried. That was a big one because they didn't want the people over here acquitting them. Nope. We're going to transport you over here into the King's Bench so we can kill you. But why should we enumerate our injuries in detail? By one statute it is declared that Parliament can, of right, make laws to bind us in all cases whatsoever. Now, don't you think when our form of government was actually created, that we limited personal jurisdiction over man? Said, no, we'll take care of the common law over here. We'll take care of that. What is to defend us against so enormous, so unlimited a power? Not a single man of those who assume it is chosen by us, or is subject to our control or influence. But on the contrary, they are all of them exempt from the operation of such laws, and an American revenue, if not diverted from the ostensible purposes for which it is raised, would actually lighten their own burdens in proportion as they increase ours. We saw the misery to which such despotism would reduce us. We for 10 years incessantly and ineffectually besieged the throne as supplicants. We reasoned, we remonstrated with Parliament in the most mild and decent language. They remonstrated before they took up arms. First Amendment, right to petition the government for the redress of grievances. Administration sensible that we should regard these oppressive measures as free men ought to do, sent over fleets and armies to enforce them. The indignation of the Americans was roused, it is true, but it was the indignation of a virtuous, loyal, and affectionate people. Okay? We all picking up what's being laid down here from history? We don't have to put up with this crap. We don't have to put up with it even though that we're not government de jure. It doesn't matter. Plain and simple. And the Supreme Court of the United States of America did just rule back in June of 2022 there in the New York State Rifle Pistol Association versus Bruin that, I'll be darned, the right to keep and bear arms comes from the laws of nature as the fundamental right of self-defense. Yeah, right. That would be this right here. What did they cite? They cited Blackstone's Commentaries on the Law of England as the first primary, fundamental, absolute right of personal liberty. Or personal security, pardon me. The rights of persons considered in their natural capacities are also of two sorts, absolute and relative. Absolute, which are such as appertain and belong to particular men merely as individuals or single persons. Relative, which are incident to them as members of society. So these are absolute rights. And standing very... By the absolute rights of individuals, we mean those which are so in their primary and strictest sense, such as would belong to their person merely in the state of nature, and which every man is entitled to enjoy, whether out of society or in it. But with regard to the absolute duties which man is bound to perform considered as a mere individual, it is not to be expected that any human municipal law should at all explain or enforce. Don't need it. For the end and the intent of such laws being only to regulate the behavior of mankind as they are members of society. Article 6, Clause 3. Members. Law of Nations, Book 1, Chapter 19, subsection 212. Citizen is a member of society who is bound to perform certain duties. Those are citizens. Citizens are the public servants of the legislative, executive, and judicial branches of government. We, the people, are in the private. Citizens are the public servants. So, these are part of the laws of nature. Right? And this is where they cited from as that first absolute right from the laws of nature, the right of self-defense, which also includes the right of health. That's in there. The absolute rights of man considered as a free agent endowed with discernment to know good from evil and with power of choosing those measures which appear to him to be most desirable are usually summed up in one general appellation denominated the natural liberty of mankind. This natural liberty consists properly in the power of acting as one thinks fit, without any restraint or control, unless by the law of nature, being a right inherent in us by birth, and one of the gifts of God to man at his creation, when he endowed him with the faculty of free will. Now, this is a contradictory statement. But every man, when he enters into society, gives up a part of his natural liberty as the price of so valuable a purchase. No. In fact, Blackstone does reiterate that here, except in America. We don't. And in fact, how can it be an absolute right if it's not absolute? So this is an attempt to subvert an absolute right. Oh, well, you give up certain rights in exchange for privileges. Why would I give up a right for a privilege and allow you to regulate me? That's just, it just blows my mind. Well, the laws of nature is the limit. I mean, I even found that in Idaho Code under rules of evidence, under judicial notice. The court takes judicial notice of the laws of nature. Well, yeah. Plain and simple. It is the law. It's common sense law. We're already supposed to know all this stuff. Interesting. Whew. All right. Good show tonight, right? Anybody disagree? Well, I hope not. So here's my website, kirkslawcorner.com, okay? For those of you that are new or don't know. Up here, upper left-hand corner here is all the links to social media, which we're broadcasting live on right now. Facebook, Telegram, YouTube, Rumble, and X. Now this one here is Patreon. For those of you that would like to help support me, that's where to go for now. You can choose how much you want to donate per month over there. You can do it for 1 month and then turn around and cancel, whatever. But I have Tier 1 set up for $5 a month, Tier 2 for $10 a month to help support me what I'm doing right here for free right now, right? And everything else I put out there for free, okay? Tier 3 is Wednesday Night Workshop. It's a private class, okay? It's where I go more in-depth about some of the things that I'm working on, and more in depth on how to do things, how to do paperwork and that kind of stuff. Okay. And then if you're looking for one-on-one time with me, that's Tier 4. If you want help with your individual case, that's where that's at. I don't do that out here. That's all done through the private. Okay. If you don't want to go through Patreon to make a donation, that's fine. You can send, good old snail mail. You can send it to me over here, Kirk Pendergrass, over here at my office. Come on. 6477 West Fairview Avenue, Suite G, as in golf. Boise, Idaho 83704. And I'll shout out to Miles here, who helps run this website and does the website here. Thank you, brother. And down here on the bottom is also another link to Patreon for Wednesday Night Workshop. So, now there's a library tab here. That's the next tab over is the library tab. All sorts of goodies. I highly recommend starting here. Treatise on Arrest and False Imprisonment, the Authority of Law, the Law of Nations, Report of the Commission on Unalienable Rights. Now, people ask about the common law sometimes. Well, here it is. Lex Parliamentary Americana. We finally got that fixed. Again, this is elements of the law and practice of legislative assemblies in the United States of America. See, it's United States of America, not just United States. That's the ink. But this is the common law stuff. People always ask, well, where can I find the common law? Right here. Right there in that book. See, that says the elements of the law and practice. There's common law in there. Otherwise, common law is our rights as the law. Okay? Mason's Manual Legislative Procedure. This is the 2010 edition. This is Jefferson's Manual, Parliamentary Practice. And then this is the 1953 edition of Mason's Manual Legislative Procedure. Commentaries on the Constitution by Joseph Story. Okay? All 3 volumes here. Then here's Bouvet's Law Dictionary, right here. The number 1 there to the left. Black's Law Dictionary, 4th edition. And Maxims of Law. Here's your common law. Which recently discovered there in Blackstone's Commentaries on the Law of England, the origin of the common law was done by the Saxons, which is Maxims of Law and Customs. Well, imagine that. It's not stare decisis, it's not case law. No, it's maxims of law. That's that common sense law stuff, you know? Like what a man does in his defense is to be considered legal. That's right, because the fundamental law of laws of nature dictate that we have the right to defend ourselves. That's a common sense law. That's common law. All right? And then, of course, National Assembly, Thursday nights. Just reiterating this. The second tab over here next to the home tab, conference call info. This is how you get there. And free conference call is a free app. You can download this on your smartphones. Here's a YouTube video on how to download and install it on your phones. This is a YouTube video how to do it on your desktop or laptop computers. Okay. Here's the link to join it. Right there, you see that? This says join the online meeting here. That's the link. This is the link right here. So when you click on that, it's going to take you right there to your free conference call and open it up. But once you do that the first time, it'll save it in there. So all you have to do is open up your free conference call. Highly recommend downloading and installing the app, folks. Okay? So that's how you get involved in the weekly call. Okay? Every Thursday night, 6 p.m. Pacific, 9 p.m. Eastern. Now I want to remind people or let people know that don't know. Make sure that you mute yourself and keep yourself muted. Seems to be a difficult task for people to keep themselves muted when they're not speaking. We need the people to come together here. Now, under the Forums and Blog tab, National Assembly Forums, you can go into there. Scroll down here. to the 50 nation states. This is how you can get connected. Okay, all 50 of them are here. It has an introduction, it has the general chat, and it has the historical documents in there. Some of them do. But that's one way to get connected, is through here, which some people watch this, some people don't. It's fairly, looks like there's, some people doing some stuff on there. Scrimshaw, you're back here February 19th, 2024. Somebody on here, January 2024. February 2024. That's me. Idaho. Otherwise, well, that opened up that. Under the Contact Us email, you can click on the email, and it's Content Manager 1, the number 1, at yahoo.com. Okay, that'll come up. And send them an email and say, hey, I'd like to get in contact with the coordinator or whoever, whatever's going on in that particular state. Okay? To get involved. Come on, people. Let's get her done. We need the people to come together and reassemble government de jure. All political power is inherent in the people, but the people have to be lawfully assembled. If we're not lawfully assembled, we can't do nothing. So let's get her done, folks. Let's get lawfully assembled. Let's reassemble government de jure and get rid of the government de facto. They're only there because we're not assembled. That's it. Right? Diesel D's. We can become the new founding fathers. Well, I kind of feel like I am with what I'm doing. And I want to thank everybody that's showed up here tonight and watches these later. I greatly appreciate you folks being here. Pass the word around, folks. Start talking to people and getting people onto the National Assembly call. We need to focus. This is what we need. We have to do this, folks. We have to come together. We have to unite. Put your petty stuff to the side. Leave it at the door. Let's focus on what needs to be done for liberty, for justice for all. Of the people, by the people, for the people. Not of the esquires, by the esquires, and for the esquires. All to protect their satanic ritual crap. Pedophilia. Line their own pockets, enforcing these bills of attainder, bills of pains and penalties. Not to mention all the bonds they do on the backside of the cases. The bid bond, the performance bond, and the payment bond. Yeah, all these bonds. Because there is no real money. Everything's been held in trust. So, it's just a matter of time, folks. It's coming. We need to come together, folks. There's no ifs, ands, or buts about it. We have a republic if we can keep it. Well, we've lost our republic per se because the seats are vacant. Well, technically speaking, there's people sitting in it, but most of them are corrupt. All right, folks. Have a wonderful night. And for those of you in Patreon, Wednesday night, we'll see you Wednesday night for Wednesday night workshop. Thursday night, folks. Seriously, please download and install the app right now, tonight. So that way you're ready. You can even click on that link. Get it saved into your free conference call app. So you don't even have to go to the website. You're all ready to go. When that time rolls around, get on there a few minutes early and be there waiting. Okay? God bless everybody. God bless America. God bless the world. Where we go one, we go all.